Barrios from the Empire Justice Center, and the Empire Justice Center, Saima Akhtar and I are hosting this event, although we're going to have very little to do with the content. We have been working with Sam Faduski, the presenter, and have learned so much that we were excited to share what we have been learning from Sam with all of you. And I'm so excited about the number of people who have registered for this webinar. We had 100 people register, and as I'm looking at my participant list, 91 of them are already on this call. And I believe you all got an email from Michelle ahead of time to tell you that two things. One, that we are going to be reoffering this. If you have colleagues who weren't able to register because it was closed, we will be reoffering it. Also, we are recording it so that folks will be able to view it again remotely. By way of introduction, some of you know Sam. Sam, who uses pronouns they, them, and their, is an attorney with the Public Utility Law Project. Many of you know Sam because they worked at Legal Services for Central New York up through 2019. Their professional focus is on the intersection of utility rights and public benefits at the Public Utility Law Project. I, for one, am very excited that PULP has made the commitment to have staff available to those of us out in the field. It's such a great resource because it is such a specialized and technical area. Sam currently focuses their work in Western New York, but also takes cases throughout New York State. And Sam, is there anything else that I forgot to say by way of introduction?
I don't think so. I think that is about it.
Okay. Sam, did you mean to have your photograph blocked, your video?
I do currently, just because of the angle that I'm at. Once I get to questions, I'm gonna open up my video again.
Okay, that's fine. One other thing, I'm glad you just said that, Sam. Since we have so many participants on this call, we're going to save the last 15 minutes of the presentation for questions. What we would ask you to do is please put the questions in the chat box, and I will be monitoring the questions, and when we reach the appointed time, I will I'll read the question to Sam, and then at that point you can feel free to mute yourself, which you can do by pushing the space bar, and make yourself visible if you would like, if you want to amplify your question in any way. So I think that's about it with respect to housekeeping items. So without further ado, and I'll let you know, we have reached our limit of 100 participants. I'm really excited that so many people registered for this. So welcome everybody, and Sam, take it away.
All right, thank you, Susan. So as Susan said, my name is Sam Faduski. I am attorney with the Public Utility Law Project of New York. This is our contact information. So we are available on Facebook, of course. Currently, we are all working remotely, of course, during this time. However, we are still taking new intakes. The easiest way to reach someone if you're having an issue is going to be to call that toll-free number. That is our intake line, and from there, someone will be able to assist you. I've also included my contact information, and this presentation is available. So if you need at any point, if you need my contact information at any point, you can feel free to use it. That number is my direct line, so I'm still able to access it currently when I'm working from home. And of course, I'm very easily accessible by email. So what this presentation is going to do is it's going to touch on a couple of different issues. It's going to look at both the current situation with COVID-19 and how that's impacted public utilities in New York State. And it's also going to do more of a general overview of the issues surrounding public utilities. I know we have both attorneys and non-attorneys on this call, so I'm going to try to make it with as little legal jargon as I possibly can. And again, if you have further questions when this is done, or if you are an attorney and you're looking for any of the law that I cited to in this presentation, please feel free to reach out and I can provide that. So what we're going to start with is the very basic question of what a public utility is. A public utility is an entity that provides customers with vital public services. So when you're discussing most utilities, you're looking at electric, gas, and water services. You can also discuss steam services, phone, internet, things like that. Most public utilities are monopolies, and they're using public rights of way. So they're going to be using, of course, you'll see the lines on the street, they're using sidewalks, they may be underground in some areas, and that's how they're providing their services. In return for the monopoly status and their ability to use the public rights of way, public utilities are regulated. So even though they're owned by a private company, they're generally regulated by a state entity. Here in New York State, it's regulated by the Public Service Commission, also known as the PSC. These are the most common utility issues that we see in our office. I'm sure many of you also see them with your customers. So of course, high utility rates is a huge issue. Shutoffs, both receiving shutoff notices and customers being shut off. Problems with deferred payment agreements, denials of service, issues receiving assistance to pay utility bills, problems with complaints, and also issues with energy service companies, which I will call ESCOs for the rest of this presentation. In addition to those general issues that we see on a day-to-day basis, we've started to see some new issues with the current crisis. And so that includes companies not following the moratorium on shutoffs, landlords requesting illegal shutoffs during this time, and customers who did not have service pre-pandemic who are now struggling to get their service reconnected. This is just a quick overview of what we're covering. Again, this is the different law that I'm citing to in this. If you want more copies of this or you want more information on it, feel free to reach out. For the non-attorneys, again, don't worry. I will go over this without a whole lot of needing to know the law. Of course, first thing I'm going to touch on is on affordability. Many customers in New York State cannot afford their utility bills. The electric and gas utilities had issued 6.8 million shutoffs in a year. More than 1 million customers owed in excess of $750 million. And these numbers, as you can tell, are from 2018. This number is growing rapidly, especially during the current crisis. So customers who may have previously always been up to date on bills, or maybe they had not been up to date, but they had not fallen that far behind, are now falling behind. And so we're looking at even higher arrear amounts during this time. Additionally, service being terminated, it looked around 200,000 customers in 2018. We're assuming that that's going to be higher, much higher, once this moratorium is lifted. The first area that I'm going to discuss is coming out of the Home Energy Fair Practices Act. It's abbreviated as HEFA. It's also known as the Utility Payers Bill of Rights. This is the areas of the law in which you can find it in. This touches, the first area we're going to talk about is if your customer can't pay their utility bill. A utility cannot take any action until a utility bill payment is at least 20 days past due. Once you hit the 20 days past due, the utility has to then issue a final termination notice 15 days before the shutoff, which means the earliest a termination can occur is 35 days after the payment is due. So it is not a situation where the customer misses their payment and then the next day they're terminated. Some time passes in between then, and the earliest it can happen is 35 days after. There are also specific times that a utility can terminate electric or natural gas service. It has to be Monday through Thursday from 8 to 4, which means there can be no terminations on Fridays, cannot be terminations on the weekend, there cannot be terminations in the evening. If the utility's main office is closed, there cannot be terminations then. Here in New York State, we have what we generally refer to as an unofficial moratorium on shutoffs, and this period is between Christmas and New Year's Day, so there should not be any terminations during that time either. During the winter, in addition to the 35 days past due that you'll see any other time, there's also a little bit of additional procedure that goes on. And for the purposes of the utility, winter is defined as November 1st through April 15th. Although, as I'm sure many people who are on this presentation know, winter goes much longer here in New York. It's currently snowing in Buffalo, where I am right now. But during November 1st through April 15th, you have to try to contact an adult by either phone or in person 72 hours before the shutoff, and you have to attempt to contact an adult before you terminate. So when you're going to terminate the service, another attempt has to be made to contact someone in the home. Your customer has a medical problem. So this refers to a medical condition that would be aggravated by termination of service. There's a couple of common ones. The first one is a CPAP machine. So if a customer needs electricity to run their CPAP machine, and if a customer is diabetic and has insulin that needs to be refrigerated, of course, having service terminated would negatively impact that, and they're at risk of termination. The first thing that should happen is you should have the customer's doctor contact the utility and advise them of this condition. Now, this telephone certification is only good for 5 days, but it's just a first start to ensure that the customer is not terminated before we get, before anything else happens. Then after the phone certification goes in, the next certification needed is a written certification. Those are good for 30 days, and you'll see here they have to contain very, very specific information. They have to contain the doctor's name, the address, the state registration number, the name and address of the utility customer, the nature of the medical condition, and a statement that will be aggravated by termination of service with reasons supporting this. If you have this situation come up, feel free again to reach out to our office before requesting this certification. If certain things are not put in the letter, which is what's listed here, the utility can reject the letter, and then that, of course, extends this process, and it can be really, really troubling for the customer. There's also the case of life-saving equipment, which you will see if you have a customer on life support in the home. And with that, the utility, again, cannot terminate service. There's special conditions with that, and that's something that, again, the certification has to be updated fairly routinely. And if you have this situation coming up, again, feel free to reach out. We can assist you or your office with all the information you need for this. The next area is deferred payment agreements, or DPAs. These are written agreements to pay back arrears. So if you have a customer who owes a certain amount to their utility company, this is a way to have them slowly pay this back over time without needing to pay the full amount up front. The primary requirements for a DPA are they have to be in writing, and they have to be signed by both the customer and the utility representative. Now, a DPA may require a down payment. You will generally see a requirement of a down payment if the customer has defaulted on the DPA in the past. They have to be tailored to the customer's financial situation. If you have a low-income customer, the utility is supposed to offer what is called a minimum DPA. Minimum DPA is $10 a month on top of their bill and $0 down. In order to do this, you may be required to do a financial statement, but if you have a low-income customer, you should advocate for them with the utility. They need a minimum DPA. In addition, the DPAs can be changed if the customer's financial situation changes. So in light of the current situation, especially if you have customers who have deferred payment agreements, I would recommend trying to get them lowered if possible, if it's something they can no longer afford. Even in the future, if you have a customer who is on a DPA and they lose their job or they change jobs, something like that, it's important to reach out to the utility and change the DPA so that it matches better with what the customer is having coming in, and so we don't run into an issue with them defaulting on it. The DPAs are very useful because the utility cannot terminate service, deny an application for service, or refuse to reconnect a customer until they've offered a DPA. So at any point, if you have a customer with a shut-off notice or a customer who is already shut off trying to get service, the utility is supposed to offer them some sort of deferred payment agreement. If they do not offer the deferred payment agreement, it's against the law. It's as simple as that. If they are not offering a DPA and they're refusing to give service, it's grounds for a complaint, and it's something you should file if that's the case. So public utilities, and again, electric, gas, water, have a duty to serve. This is an incredibly old duty, and it's something that basically means that a utility has to provide service. There are some very narrow exceptions, and there are certain small requirements they can make, but they have to provide service to customers. When you have a new customer who's applying for service, a utility may require a written application. There are only certain times in which this can be required, and that is if service was terminated for non-payment, if there was evidence of meter tampering, and so if there was an issue where the customer's meter appeared to have had power stolen from it, something like that, that can require a written application, and an application made by a third person. So if you, an advocate, are applying for service on behalf of one of your customers, then you may have to file a written application. If a customer's utility service application is denied within 3 days of the application, the utility has to provide the reason for the denial and what has to happen for them to qualify for service. A lot of the time, this is a deferred payment agreement if the customer has a back or rear amount. The other thing that has to be included in this notice is the applicant's right to request a review by the Public Service Commission. And so if the customer disagrees with the reason that's been given, they can request that the PSC review this. You generally cannot be required to pay a security deposit to get utility service. Unless you're a short-term or a seasonal customer, note that this is different than requiring a deposit before a DPA. This is just a security deposit to get service. So if you have a customer who is trying to move into an apartment and the utility says they need to put down some form of security deposit, unless they're short-term or seasonal, they can't be required to put that deposit down. If you have a customer who owes utilities for an old apartment, so they had lived in an apartment, they had built up a back balance, and now they're moving and attempting to get service into a new apartment, or if they had not had service in their name for a little bit and now they're having service in their name again, you owe this back amount, they can enter into a deferred payment agreement to pay the back amount. They can also pay in full, although most of the time, if they could pay in full, the back amount would not be there. So we see a lot of deferred payment agreements that can come in, and the utility again has to offer the deferred payment agreement. Again, I have said this a few times, but I do really want to make this clear. If you have a low-income customer who has not defaulted on a DPA in the past, they are eligible for a zero down $10 a month DPA. This is something that I think is really important. This is something that we end up seeing a lot of low-income customers who end up with unaffordable DPAs. This is something that shouldn't be happening. So ensure that if your customer is starting on a deferred payment agreement, it's something that's going to be affordable for them long-term. When you're looking at a security deposit for continuing service, this can only happen if the customer is delinquent in paying bills. Here, delinquent is defined as having 2 consecutive months of arrears or termination for non-payment in the past 6 months. The next area that we're going to look at is a couple of different assistance amount things for low-income customers. So there's a variety of options here, and we'll just go over them to kind of explain what each of them does and what might be the best solution for your customer. First one I'm going to talk about is a 131S grant, also known as a one-shot deal. It's an option when HEAP is not available. So the one-shot deal is available year-round. It is something that is offered through DSS throughout the year, not just during the winter. You do not have to be eligible for public assistance to receive a 131S grant or loan. You do have to be a tenant and a customer of record. And to prove tenancy, generally we have them do a lease. You can also do a mortgage book if it's somebody who owns their home. You can have a landlord statement. Customer of record is generally proven by the utility bill. If you have a customer who is applying for this, if they're receiving emergency assistance, if they would be eligible for emergency assistance, or if they are below a certain income threshold, they will not have to repay any amount that has come up through 131S. If you have a customer who is above this eligibility guideline, it comes out as a loan through DSS instead, and they will have to pay it back. The repayment amount can be flexible per month, but it is something to consider when you have a customer who's applying for this. If they're not eligible for the grant, that is another amount they will have to pay back. Another thing to flag is that if you have a customer who is currently defaulted on a DSS repayment, so if they had an overpayment or a sanction through their local DSS, they're not going to be eligible for another grant until they're current on that. And so just to discuss the 131S grants a little further, this is very useful if you have a customer who is requiring a down payment to get started on a DPA, for example. They can go get this amount and that will count as their down payment and then be started on the DPA. This is also good if you have a customer who has a high amount of arrears, just to kind of bring that arrear amount down a little bit. Next area is HEAP. HEAP, I'm sure most of you are familiar with this, but I'm going to go over it, is something that is available for low-income households. There's a couple of HEAP eligibility guidelines that can be challenging for some customers, so I'll just go over them briefly here. The customer and the household member has to be U.S. citizens or qualified aliens. Have to be at or below income guidelines. Income guidelines are generally around 185% of the federal poverty line, so it is higher. You can make more money than if you were to be eligible for public assistance, but it is still low. If you receive SNAP, temporary assistance, or if you are on SSI living alone, which is a code A, then you're going to be automatically categorically eligible for HEAP. And your HEAP payment amount is determined based on a few things. The first is how much income you have. The second is how many vulnerable household members you have. And then the third is your energy burden. When looking at the income guidelines, the program is going to look at if public assistance is being received, so PA, SSI, or SNAP, or they're just going to look at the gross monthly household income. And there is a chart on OTDA's website that will go through the current guidelines for this year. The levels change a little bit every year, but the current ones are up on OTDA's website. As I had discussed a little earlier in the slides, They look at vulnerable household members to determine your HEAP grant amount. Vulnerable household members are defined as someone who is disabled, under the age of 6, or frail, or over the age of 60. There are a few different types of HEAP payments. The first is regular HEAP, which is made directly based on the household income. Everyone is eligible for this as long as they're below the guidelines. That is the HEAP season that opens up on November 1st, generally. The next type is emergency HEAP. Emergency HEAP is issued after the regular HEAP payment, and it's available for customers if they are at risk of termination or if they're without fuel of some kind. So it's not only for customers who are being heated with electric or natural gas and who are getting a termination notice, but if you have a customer who is, for example, heating with wood and they are out and do not have money to purchase more, that is another option, is emergency HEAP. Households who have heat included in their rent are still eligible for HEAP. They just get a smaller amount. We generally refer to that as renter's HEAP. I do want to flag for everyone that when you see the renter's HEAP amount coming in, generally we have been seeing it come through as an amount on a benefit card. So if your customer gets their benefits on their EBT card or a benefits card, sometimes that's where you'll see the renter's HEAP amount come in. Qualifying for emergency HEAP. So you have to be HEAP eligible to receive emergency HEAP first. And then in addition to that, you either have to be without service or be at risk of termination. You can also be eligible for emergency HEAP if you have heating equipment that's in need of repair. And if you're in it, pretty much it's for emergencies, hence the name. The next portion is just, again, brushing on the renter's HEAP benefit. When you receive renter's HEAP, so for many people, they don't really think about it because it is a small amount, but what it does is it provides eligibility for low-income programs. Under the low-income order in New York State, all utilities that are regulated by the Public Service Commission have to have a low-income plan. So mostly that is electric and gas. If you receive HEAP, you are automatically eligible for those. And for a lot of these programs, you need to receive HEAP to be eligible. So even if you have a customer who has heat included in their rent, getting this will assist with getting them on the low income program, which will help them out. And so this briefly, so when we're going to the utility funded issues, I briefly discussed that, talking about reduced rates for low income customers. Under the low income order, there are multiple tiers for customers. It is based on the HEAP tiers. And so if you have a low income customer who is receiving electric or gas services, should contact their utility and request that they are put on the low income plan. The utility offers discounts to low income customers based on this. It's very useful. I recommend it to everyone. There are a variety of utilities who offer these rates. On top of electric and gas, there are a few telecom providers that also offer this. I know Spectrum, for specific circumstances, offers reduced cost internet for low-income customers. And so this is definitely an option to ensure that your customers' utility bills remain affordable. Some utilities have arrears management programs. This greatly varies from utility to utility, and it's really going to depend on which utility you're working with. NYSERDA offers low-income energy efficiency programs. These are very useful if you have low-income customers who own their home. They can help with things like weatherization, which of course will lower bills in the long run. Your other option is to look at utility charities. So specifically during the winter months, there are a few utilities. The ones that I can think of off the top of my head are National Grid and National Fuel, who offer their own separate charity programs to assist customers who have arrears. And so that is another option if you have exhausted a lot of these other options. We also generally recommend if you have a customer with high arrears where you can't find a way to pay their bills, they can talk to nonprofits. Some of you may work for nonprofits who provide some of this funding, Catholic Charities, Salvation Army, there are local faith-based groups. These are all options that are available if you've exhausted the other potential options from other sources. Okay, the next area is the New York State Public Service Commission complaints. This number is the Public Service Commission's hotline. The hotline is different from the complaint line. So if you have a situation where a customer has been terminated unjustly, this is the number that you should call. They're open until 7:30. They have power to direct a utility to restore service. And it's something that if you have any case where a customer has their service terminated, it should not have happened, or you're having an issue with it, make sure you contact the Public Service Commission, the regulatory authority for all utilities in New York State. It's important to make sure that this is happening. If you have another customer complaint, so if your customer has a bill that they think is too high, if they think that their power is being stolen or that they have a shared meter situation, if they think that they have a back bill amount that is unjust, any issue that may come up, they can file a complaint again with the Public Service Commission. So we recommend that you both call the complaint line and file a complaint online. It's important to make sure you have documented records in writing, so that way you have proof of when things were filed in case this has to go to a further point. Now, after you file your complaint with the Public Service Commission, what they do is they send it to the utility to resolve. The utility has to respond to the customer within 2 business days. So you file the complaint, it goes to the utility, and then from there, the utility is supposed to have 2 days to respond to your customer. Now, a lot of the time, this is not going to resolve the issue. Generally, by the time that it has gotten to a PSC complaint, the customer has attempted to work with the utility and it was unsuccessful. And so if the issue is not resolved, you have to contact the PSC again and state that you're escalating the complaint. Once the complaint is escalated, the commission is going to further investigate the complaint, and from there, it's going to make a determination. Now, if you receive a determination that you believe is incorrect, you can request an informal hearing. You can also request an informal review. The request has to be made within 15 days of the initial decision. So this is something that is very time sensitive. If this is the case and your customer wants to proceed with an informal hearing or review, it's really important that you request the informal hearing as soon as possible in order to preserve this right. At the informal hearing, there will be a representative from the utility there. The customer will be there. The customer can bring a representative, and they will discuss the facts of the case with the hearing officer, and the hearing officer is then supposed to make a decision and notify the customer in writing of this decision. Now, if you do this and you receive that the hearing officer's decision is wrong, this can be appealed. Again, this is a 15-day window in which you can appeal. So it's really important that if this is what you're doing, you need to do it really quickly. The appeal has to be in writing, and it needs to show that there was an error made by the hearing officer. Generally, we say it's an error of fact or law, or there is evidence that was not previously available. If this happens, you appeal, and then you get the decision, and you believe that that decision is wrong. First, you have to file a petition for rehearing within 30 days. And once you've done that, you have exhausted your remedies and you can bring an Article 78 proceeding. Once you're getting into these, this is again another instance where feel free to contact our office. If you get to a point where the commission has rejected your complaint or given you a decision and you want to proceed with an informal hearing, I do strongly recommend that you contact an attorney before you go into the informal hearing. I do really recommend you contact them as soon as possible. Again, this is something that's very time sensitive. This can move really, really quickly. And so it's easiest if you contact the attorney as soon as possible so they have more time to work on it and to assist your customer. And now we are going to get to our COVID-19 issues, which has been the topic of every webinar I'm sure you all have been a part of for the past couple of weeks now. So on March 13th of this year, an order was brought out that stated that all energy and water utilities under control of the Public Service Commission should halt terminations. So this includes the vast majority of electric and gas utilities in New York State and a few of the water utilities. I want to make a note that this does not include municipal utilities. So when you are looking at most major cities' water, for example, they're usually run by the city. And so that is not covered by this. However, a lot of municipal entities have put their own moratoriums on terminations. That's something that you would have to check with the local utility on. I know here in Buffalo, we've had an unofficial moratorium put out on water. If you have an issue in your city regarding moratorium, again, please feel free to reach out to our office. This is something we've been working on as well. All ESCOs, so the energy service corporations, are supposed to stop door-to-door solicitations. Where you may have heard of an ESCO doing a door-to-door solicitation is when you have a customer who has someone come to their door claiming to be the utility company, saying they can save them money on their bill, or saying that they're going to have cheaper service than if they went through the utility. That is an ESCO. They are not supposed to be going door-to-door right now. That is not something you should be seeing. You should not have any customers who are seeing ESCOs come up. In addition, HEAP has been extended until June 30th. So if you have customers who have not applied for HEAP yet and who are eligible for HEAP, that period has been extended to June 30th. There's also a third round of eHEAP available. So we had a second round that came out. I do not know the exact date, so I'm not going to say it. However, there is a third round now. So again, if you have a customer who has used the first two eHEAP payments and is eligible for another eHEAP payment, you should have them apply for a third round of eHEAP. A little bit of troubleshooting during this time. If you have a customer whose electric or gas is shut off for any reason, file a complaint with the PSC immediately. File a complaint on their emergency line. Again, there are supposed to be no shutoffs for PSC utilities during this time. Doesn't matter if the customer has not paid their utility, it does not matter. They're not supposed to have a termination of service during this time. Also, please reach out to our office if you are having any issues with this. This is what we have primarily been doing during this time, is working with shutoffs, but your first step is going to be to contact PSC and then feel free to reach out to us. As I stated, no power can be shut off anytime. This includes landlords cannot shut off a customer's power. So this is an issue that I've seen a handful of times since all this has started, where because customers are not paying their rent, landlords in retaliation are terminating the utilities that are included in their rent. This is still illegal. The landlords cannot do this. This is not something they have the ability to do. There's not supposed to be any termination of service. If this issue comes up, you have a few options. I would again recommend contacting our office. You can actually contact me specifically because this is my area of focus currently. You can also contact the utility. And again, you should file a complaint with the PSC. If you have a customer who has had power terminated pre-moratorium, So this is a customer who maybe didn't have electric or gas for a couple months before this, or even a month before this, and now they're trying to get service back on. Currently, reconnecting customers is a priority because, of course, we're in the middle of a public health crisis. It's impossible to stay safe and healthy at home if you do not have your utility service. I recommend contacting the utility to see if you can get your customer service started again. Again, if you have any issues with this, please feel free to reach out to our office. This is something, again, we're working very closely on. This is a priority for us to ensure that all customers are safe in their homes, that they have electric and gas service, and that there are no concerns with this. And this is, again, my contact information. I almost timed it perfectly to 2:45. So I guess the next area is going to be getting started with some questions.
So here we go. Hi, this is Susan. Can you hear me? So we do have a lot of questions, so I'm glad that Sam, you were able to end your presentation at 2:45. I'm going to take them in the order that they came in. Some people sent them to me privately as well as to the group, so I have a bunch of them. So I'm taking them in the order they're received. And just a reminder, if you are the person who asked the question, you can unmute yourself by hitting your space bar. If I haven't, if you have more that you want to add to your question. So the first question is from Julie Morse. How do they have to document an attempt to contact an adult resident, and can that be used as a defense if it is not done? I assume that means before a shutoff.
Yes, so the utility should have proof that they attempted to contact an adult resident. Yes, that can be used as a defense if that was not done. I have had some success in stating that that has not happened before.
Okay. The next question is, must the utility offer a deferred payment agreement, and must the client request it, or is the utility company's duty to affirmatively offer? And how quickly does the PSC review a denial of services request?
So the DPA has to be offered. It's not something that the customer has to request. It's something that has to be offered by the company. They don't have to offer a minimum, which is where you'll sometimes see issues, is where they'll offer what appears in my mind to be a really high DPA, but they do have to offer it outright. As far as when is the PSC going to look over a denial of service, they're supposed to do it quickly. It is something that if you're having an issue with it, I would recommend escalating the complaint. It is something we randomly do see problems with, especially right now with everything that's going on. Times seem to be a little slowed down.
And a related question is, are there minimums, are there standards for when the minimum DPA must be accepted?
So the general standard is that the customer has to be low income in order for the minimum DPA to go in. The standards for low income vary from utility to utility. Most of the time, a utility will require a filing of a financial statement in order to prove this. And so that's something that once you request it, the utility should be able to state to you what their definition of low income is for the situation. If they do not, or if they attempt to act like they don't know what you're talking about, that's just simply not true. They may, again, they may require a financial statement, but that's generally as far as they should go.
Okay. And are the standards of each utility company public, or they'll let you know once you've filed it?
I will double check that. I believe they are public, but it's something I would have to double check.
Okay. The next question is, hold on, it's just scrolling down here. This is from Danielle Bernard. What is the definition of short-term, and what about a month-to-month tenant?
definition of short-term, I believe, is under 3 months. A month-to-month tenant, that would be something that would be up for debate. If the utility really wanted to fight you on it, it's something they could, but generally a month-to-month tenant is not defined automatically as short-term. As far as the actual short-term definition, I can look that up. It is definitely in the law, and I can get back to you on that.
Great. And again, I just want to repeat, if I'm asking your question and you want to add or supplement to it, just unmute yourself and weigh into the conversation. The next one is from Esther Weingarten. I have advice for those who can't get a 131S because of prior default and can't get a DPA that can afford if they have defaulted in the past also.
Can you repeat that question? I'm sorry.
Okay. Do you have advice for those who, I'll break it into 2 parts. Do you have advice for those who can't get a 131S grant because of a prior default?
I think the first thing is a lot of the time to have the customer go in with an attorney. So sometimes the customer will get denied their 131S grant and the DSS will have some statement for it. If you go in, but we've had a lot of luck with that being helpful, is just having somebody who has a little more pull, I suppose, with DSS going in and stating they need the 131S. The other option is to do it as a loan instead of the grant. Again, this is of course not the most favorable option because they will have to pay it back, but the payment terms are a lot better on paying back a 131S loan than they would be to try to get that amount fully outright.
And what about people who can't get a DPA they can afford? And the question seems to indicate, it says if they had defaulted there in the past also. So I guess the DPA is being denied because of a past default. Esther, weigh in if I'm interpreting this wrong.
Nope, that's right. Thank you.
So even if a customer defaulted in the past, they are still eligible for the $10 a month if they're low income. The issue I'm assuming that you're talking about is when they're requiring a certain amount of money up front for the deposit, which is of course something that can be a pain. Again, attempting to do the 131S as a loan instead of a grant if they're not eligible for the grant. The other options are really to look into just other options in your community. Catholic Charities is an option, Salvation Army, your local nonprofits. Those issues are more tricky, and I know that those are, of course, the more difficult ones when you have that situation come up. Our office is always available to assist when you have issues with those.
The next question is from Sandra Gressel to everyone, and the question is, how does the utility arrears management program differ from the DPA?
So the utility arrears management program is specific to certain utilities. Some utilities, and I think right now we only have 1 or 2 in New York State, have their own separate programs that are totally separate from having a DPA, where they might do their own type of payment forgiveness if you have a certain amount of appropriate payments, something like that. Again, that fully varies from utility to utility. So not all utilities offer it. Some utilities offer different ones. And so that's something where you would have to contact the utility in question specifically. But the difference is that a DPA, every utility offers a DPA. Oh, and to clarify that, only NYSEG and National Fuel currently offer utility arrears management programs. So if it's not one of those 2 utilities, you're not going to be able to find it currently.
Thanks, that's helpful. Next question is from Julie Morse. Can PSC hotline get the services restored the same day you call, even if it's after 4 p.m.?
They can sometimes. Again, unfortunately, in a situation where it does depend, but the utility is able to turn service on after 4 p.m. So they can't terminate after 4, but they can turn service on after 4.
Okay. Next question is from Danielle Bernard. Do you have a contact at the New York State Power Authority which regulates the rural cooperatives. The Power Authority has termination regulations similar to PSC regs, but it does not have a hotline. Our rural cooperative, Steuben Rural Electric, did not join the PSC utilities in a moratorium on electricity terminations. It has threatened several clients with termination.
Danielle, can you reach out to me? And then I think my email is in there, and then I'll be able to talk to you a little more about NIFA.
Okay. It won't be me. It's the person that really wants to know wasn't able to join. I mean, I want to know too, but they're the one with the. But I will give you your information. Thank you.
The next question is from Steve Nguyen. Can a utility company terminate for non-payment of arrears that have been forwarded to a customer's current account? And then there's a second question, but I'll do it one at a time.
So if there had been back arrears from an old account and the customer has a new account, that is something that you could see a termination notice come up for. So even if the debt was not incurred at the apartment they're currently at, as long as it was in the customer's name, that is something you could see a termination notice come up for. So, but again, that's something where a DPA should really be done.
Also, are there time limits as to when a utility can forward a prior account balance?
There is supposed to be a limit. So if there has been a break where the customer has not had any sort of utility in 6 years, they're not supposed to forward it from the 6-year mark. That is another thing where you're going to see utility customers, not utility customers, where you're going to see utilities argue certain things. They're going to say that statute of limitations has been restarted if the customer has continued service, but generally it's 6 years.
Just to follow up on that myself, because I had a client with this issue, is that in a regulation somewhere that's 6 years?
It's with the statute of limitations, but it is a regulation, so that is
Okay.
something I can find.
Thanks. Okay, next question. Can you, from Trista O'Hara, can you go over really quick when a down payment can ever be required?
Yep. So down payments can be required, one, to get started on a DPA if the DPA had been defaulted on in the past. Down payment as a security deposit can be required if the customer is seasonal, or if the customer is delinquent on bills to have service and the delinquency is determined by a shutoff within the past 6 months or 2 months without payment.
Okay, and this is kind of a related question, just followed in time. But you might want to add to what you just said. Is there any way to get around the down payment the utility company requires for the DPA?
It's going to depend on your customer circumstance. So if you have a low income customer, yes, they should not be offering the down payment. Unfortunately, when you're looking at a non-low income customer or a customer who is defaulted on a DPA, it's not going to be something where you can get fully out of the down payment. It may be something you can argue to get lowered. So if you have a customer, for example, where they're saying they need to pay $1,000, you might be able to talk to the company and get them to lower that amount, at least to a point where you can get some sort of grant for that. But unfortunately, unless the customer is low income and has not had a default before, there's not a way to fully get out of the down payment.
The next question is from Heather Kuchia. And is there a one-sheeter which may be provided with basic information for us to provide the communities we serve? And I guess Heather, please weigh in. Are you talking about a pulp generated one-sheeter?
Just one, hello? Just the one sheet of that. I mean, just in the interest of, I know the presentation covered a lot, but I do community engagement for all of Nassau County. So I was just curious if there was something that if somebody asked us about utilities, if there was something that I could provide in terms of a sheeter that would at least give them general information and who to contact.
Yes, so we offer a really cool foldout called Shine a Light. It folds out into a poster-sized pamphlet that has all the information, pretty much most of the information on this slide. It's meant to be easy to read. It's colorful, it's bright, it's very, very useful. We have a lot of them. If you can email me with an address, we can generally send them to you. We give them out a lot at different events as well.
Sure. Is that anything also digital, Sam? I'm sorry.
I have a
Like a
digital
PDF?
one with the current COVID ones. I will have to double check with my team to see if we have a digital version of that currently for the
All right. I'll make sure to email you. Thank you very much.
Sam, if that's something that is available digitally, we can send it out to everyone who's registered as well.
Okay.
So just let me know, and then we can. So I just want to say we only have 4 minutes left, and I'll probably be able to get one or more questions. If I don't get to your question, we've gotten to most of them. Michelle, is there a way that, do these chats get preserved as well, so that Sam could get back to the questions we weren't able to answer?
Yes, we will have a chat log, so I
Oh,
can forward those
great.
on.
Okay, thanks.
Yep.
All right, so maybe 1 or 2 more questions. This is from Claire Mooney, and I'm not sure I know, so it's WRT is.
Sorry, I'm just saying that for, I'm just mentioning that mutual aid networks often have resources to help with grants where folks are having trouble paying their down payments and other opportunities have been exhausted. It was just kind of an FYI.
Okay. Does everyone know what a COVID mutual aid network is? I don't. Can you explain that?
I can, it's kind of, I'll email you later about it so that we can circulate to the group if it would be helpful.
Okay, I think that would be great. And unless, Sam, do you have something you want to add about COVID mutual aid groups?
No, I think Claire is going to do a great job with the email. But yes, that is definitely a good option.
Okay, and I guess this will probably be the last question. What about ID theft issues for arrears that are added to accounts? What to do in that scenario? And that's by Jeffrey Center. I don't know if you want to say anything more about that, Jeffrey.
I mean, I can start with just that. That is something we do see, both a combination of identity theft and also just the general, someone has put utility bill in my name that is not mine. You can first file a complaint with the PSC. That is something that is your first option. You're going to want to have your customer also, they'll file a police report regarding the identity theft, because that's going to be something that you're going to need to use to go back and kind of prove the identity theft. But filing a complaint with the PSC, we have had a few of those cases in my office. So again, that's something you can feel free to reach out to our office on if you have that issue come up, just because there's so many varying options with that, whether it's somebody who knew you or if it's, you know, there's a lot of details in that, but PSC complaint will be your first step.
So we have 1 minute left, and I want to thank Sam and everyone who participated. This has been really interesting. The chat discussion has been really informative. Sam, thank you for this presentation and for all your answers. Again, the questions are still coming in at the very last minute, but we'll preserve them, and with Michelle's help, I will get the questions forwarded to Sam so that everyone will have an answer. So thank you everyone so much, and thank you especially to Sam. This has been fabulous. I've learned so much, and I'm sure everyone else has too.
Well, thank you all for joining me, especially on a Friday afternoon. And again, if you have any questions, please feel free to reach out.
All right. Take
Thank
care,
you.
everyone.
Thank you
Thank
very
you,
much.
Sam.